Okay, bear with me, guys, because, like I said, these are the facts. These are all documented, and to really kind of understand, like, who we are and what we've been through, you kind of need to get through this, because there's a lot going on. So I'm going to finish reading just the facts, and then I will read the story, like what we alleged happened. So it kind of pulls everything together in a really concise way, but I want to get through the facts, because this is actually documented. There's paperwork. Anyway, okay. On November 6, 2008, defendant Charlie D. Jenkins closed plaintiff Q. Stevens' DHS case as unable to determine. So DHS comes over here, we tell them what happened, here got burned up with the teeth, the whole 9 yards. They don't even look into the other family, and then they just close her case as unable to determine. Like, they can't determine that it's not okay to play naked games with little kids and burn them with tea kettles. DHS can't determine. Huh? You say? Okay. Plaintiff K. Stevens contacted numerous local and state officials about what happened to her daughter, and the police bureau's failure to investigate, and every state and local official that Plaintiff K. Stevens contacted declined to help her or Plaintiff Q. Stevens. I wrote so many letters and called, and it was just crazy. On November 12, 2008, defendant Reidlinger filed a notice of appeal on Plaintiff Q. Stevens' behalf. On November 12, 2008, defendant P.K. Runkles Pearson and defendant A.J. Pedersen from Stoll Reeves, LLP, defense counsel for Nike, began deposing or interrogating Plaintiff R. Stevens for a 2-day period on camera. The defendants questioned Plaintiff R. Stevens extensively about his time at Nike, his entire life, his religion, and the lawsuit involving Plaintiff K and Q. Stevens against defendant McQuiston. On November 13, 2008, Executive Assistant for the Oregon Department of Justice, defendant Jacob Weigler, stated in a letter to Plaintiff Q. Stevens that the Department of Justice has no authority to force the Portland Police to do an investigation into Plaintiff Q. Stevens' burn injury. So the DOJ can't tell the Portland Police anything. Okay, what are they there for? On November 17th, Assistant General Counsel for the Oregon State Bar, defendant Scott A. Morrill dismissed Plaintiff K. Stevens' bar complaint against defendant Kocher. Just dismissed it. He didn't do anything wrong. Sure, okay. You know, just covered up a crime. No big deal. I mean, a crime by their standards. These are their laws, mind you. These are the laws. This is the way they've set up society, and suddenly they don't have to follow any of their own rules? Come on now. Plaintiff K. Stevens filed a judicial fitness complaint for willful misconduct against defendant McShane, which was reviewed by the Judicial Board of Fitness, on December 12, 2008, and dismissed on December 26, 2008. So, once again, oh no, my friend didn't do anything wrong, okay? These people are ridiculous. I mean, seriously, the people running your society, out to lunch. Plaintiff R. Stevens deposed Claire Hamill, CEO of Exeter Brands Group, LLC, on December 17, 2008. Corey McCullough and Mary Brunke on December 18, 2008. Defendant Randy Wolf, January 7, 2009. And Richard McDivitt and Melissa Marks on January 8, 2009. And Allison Dougherty on January 9, 2009. On January 7, 2009, defendant P.K. Runkles Pearson and A.J. Pedersen deposed Plaintiff K. Stevens. On January 7, 2009, defendant P.K. Runkles Pearson, while representing Mr. Wolf in a deposition at the offices of Stoll Reeves, and I kid you not, this did in fact happen, people, jumped across the table and snatched Plaintiff R. Stevens' personal recorder and refused to return it to him until he agreed to let all the information on it be erased. So this woman, who is like this big lawyer at Stoll Reeves, which is the largest firm on the West Coast, is going to get up out her chair and jump across a conference table, okay, like a straight up lunatic, and grab Renee's recorder. And I'm like sitting there going, Renee, we need to call the police or something. But he didn't want to call the police. And so anyway, that's what she did. And so they made him erase his recorder because they had some conversation in the room, some big loud conversation that we couldn't hear, but I could hear some yelling in there. And Renee's recorder was in there, and so they made him erase the information. Just foul. It was just foul. Anyway, on January 30th, 2009, Plaintiff K. and R. Stevens attended a settlement conference with defendant Nike at Washington County Circuit Court, presided over by Judge Mark Gardner, and defendant Nike told Plaintiff R. Stevens never to apply at their company ever again. Just like that. Just foul. Judge Gardner denied Plaintiff R. Stevens' counsel when he verbally asked for it at the settlement conference. So we're asking for an attorney. Nope. On February 2nd, 2009, defendant Sylvia E. Stevens, general counsel for the Oregon State Bar, issued a letter closing Plaintiff K. Stevens' bar complaint against defendant Kocher. On February 17th, 2009, defendant Stoll Reeves LLP filed its motion for summary judgment against plaintiff R. Stevens, and on March 9th, plaintiff R. Stevens filed a comprehensive opposition to defendant Nike's motion. We always included evidence, everything, whatever. Did everything, dotted our I's, crossed our T's, doesn't matter. On March 30th, 2009, oral arguments were heard before Judge Donald R. Letourneau, and he granted Nike's motion for summary judgment without issuing a legal opinion or giving any explanation. It was so foul. I mean, it was just like 20 minutes and then just get out. No trial, no nothing, just foul. And the judge was so rude to Renee, but of course, Nike, they got all the money, so that's how it goes. On March 11, 2009, Plaintiff K. Stevens filed a complaint with the Independent Police Review, and they concurred with the Internal Affairs Department not to investigate Plaintiff K. Stevens' burn injury, and then stated that Plaintiff K. Stevens' concerns were not appealable to the Citizens Review Board because there was no formal investigation. So they conclude all these things, but they don't investigate. They don't look at any of the evidence. So what are they concluding? On May 26, 2009, defendant Letourneau dismissed without opinion and with prejudice plaintiff R. Stevens' discrimination lawsuit against Nike Exeter. That's what he did. On June 2, 2009, Internal Affairs Division declined to investigate the burn injury or the circumstances surrounding plaintiff Q. Stevens' trial. So all these agencies are just saying no investigation. Won't look into it. Won't look at the evidence. This is how this is going. On July 24, 2009, Plaintiff K. Stevens retained defendant Andy Simran to represent Plaintiff Q. Stevens on appeal to defendant McShane's judgment, and in September of 2009, defendant Simran filed the opening brief. Now, this dude just takes our case and basically steals $10,000 from us because he knew that this was a case of child abuse, and he knew this was a big cover-up, and he was just foul and slimy. But that's what he did because that's what these people do to us because we don't understand our own system. And of course we felt like if we could just keep putting her case in front of, somebody in charge, it would get dealt with appropriately, but no. These people are not innocent. How could you be found innocent when you admit that you did something completely wrong? Just wrong. Anyway. On August 6, 2010, Plaintiff R. Stevens filed his appeal against defendant Nike. On July 14, 2010, the defendants Judge Schumann, Judge Wollheim, and Judge Rosenblum, who is now our Attorney General, of the Oregon Appellate Court affirmed defendant McShane's decision without opinion. So, our own Attorney General doesn't know that it's not okay to play naked games with little kids and burn with tea kettles. I mean, she's involved in covering a crime, and that's not okay. It's just not. So, Plaintiff K. Stevens motioned for appointment of counsel for Plaintiff Q. Stevens to petition the Oregon Supreme Court for review and was denied on September 24, 2010. At this point, Kadira's like 9. Well, no, this is in 2010, so how old was she in 2010? Kadira. She was 12 at this point. And this is how they do a 12-year-old kid, so... Mind you, all the while they know that she's in internal distress because that's still going on. Plaintiff K. Stevens on her own petitioned the Oregon Supreme Court for review of Plaintiff Q. Stevens' appeal. On December 3, 2010, defendants Judge Halston, Judge Armstrong, and Judge Duncan of the Oregon Court of Appeals affirmed the judgment of defendant Letourneau without opinion and while all the material facts were at issue. So all the facts in the case are at issue. It was supposed to go to trial and they just boom. Because basically, Nike's argument was that Renee was subjected to crude jokes, like getting dry humped on the job, fired, and blacklisted is a crude joke. Yeah, I don't know who's laughing. I guess they thought they were, but that was foul. Anyway, on December 23rd, 2010, defendant Paul J. De Muniz, who is the chief judge of the Oregon Supreme Court, declined to hear Plaintiff Q. Stevens' petition for review. So they just keep telling us to get out. And that's what they do to us. In 2010, Plaintiff R. Stevens filed 3 additional charges of discrimination against defendant Nike with the Equal Opportunity Employment Commission, claiming race discrimination and retaliation. But, I mean, at this point, we did know that the EEOC doesn't do their job. I don't know. They're an agency. These people get paid all kinds of money to run this agency, but they just side with the money. Because that's what we do here. Anyway, in the summer of 2010, Plaintiff Kay Stevens discovered that she was not qualified to have been Plaintiff Q Stevens' guardian ad litem. So I find out that it's against federal law for me to have been Kadira's guardian ad litem. It's right there in the law. Because you're supposed to be an attorney or a trained CASA, which is, what is a CASA? It's like a court-appointed special advocate. So I did not have the actual qualifications to do that job, so that means that Kadira's case was overseen, obviously completely wrong, but Scott knew that. Because Scott was just foul. In August of 2010, Plaintiff Kay Stevens filed a lawsuit claiming legal malpractice, professional negligence, and emotional distress against Vangelis Kocher LLP in 2010. Defendant Callahan appeared as counsel for defendant Vangelis Kocher. Because no attorney would help me, so I had to file my own lawsuit. On March 8, 2011, Plaintiff Kay Stevens discovered that the Oregon Department of Human Services closed Plaintiff Q Stevens' investigation as unable to determine for child abuse on November 26, 2008. So all this while, I didn't know what they did with it. Plaintiff Kay Stevens requested DHS reopen Plaintiff Q Stevens' burn injury case and make a determination, but DHS refused. On March 30, 2011, the Portland Police Records Department denied Plaintiff Kay Stevens' request for Plaintiff Q Stevens' police report on the grounds that the report contained reports of child abuse. So I go to get my own kid's police report, and I can't have it. Are you hearing me? Because it contains reports of child abuse. I have a letter from the Portland Police Bureau that says this. And I'm like, are you serious? Are you kidding me right now? It contains reports of child abuse, yet Todd and Amy just walked away. Kadira got nothing. I mean, when I say nothing, she got nothing. She did not get treatment. She did not get any kind of compensation. She got nothing. They just walked away. No big deal. Burned up our kid. I mean, okay. On April 7, 2011, defendants Kocher and Vangelis, through counsel, denied the majority of Plaintiff Kay Stevens' allegations and filed a motion for summary judgment on Plaintiff Kay Stevens' third amended complaint. On April 7, 2011, defendant DeMunis declined to hear Plaintiff R. Stevens' petition for the Oregon Supreme Court review. So this is Renee's case against Nike. They say, nope, not going to listen to it, just like they did to Kadira. Plaintiff Kay Stevens filed a comprehensive opposition to summary judgment complete with testimony and evidence to support her arguments, claims, and allegations on May 16, 2011. On May 25, 2011, defendant Reese heard oral arguments on the defendant's motion for summary judgment and granted the motion in part and denied it in part without opinion and directed the plaintiff to amend her complaint. So he tells me I got to amend my complaint. Plaintiff Kay Stevens filed her fourth amended complaint on May 27, 2011, which added additional claims of intentional, reckless, and negligent infliction of emotional distress and breach of fiduciary. On June 30, 2011, the EEOC determined that defendant Nike had violated Plaintiff R. Stevens' civil rights but rescinded the determination shortly thereafter. So the EEOC says, yes, they did something wrong. Yes, Nike did something wrong, that they discriminated against Renee, but then Renee wanted to meet with Nike without any attorneys and just basically talk to them, and they said no. And then right after that, the EEOC just rescinded the determination. It was ridiculous. In the summer of 2011, the EEOC dismissed Plaintiff R. Stevens' additional charges of discrimination based on race and retaliation with 3 more indeterminate findings. So we've got 6 indeterminate findings right now. Defendant Callahan filed a motion to dismiss the allegations in Plaintiff Kay Stevens' fourth amended complaint on June 10, 2011. I wanted to say one more thing. When the EEOC gives you a determination letter, you have exactly 90 days to file a lawsuit or you lose all your rights to sue. And so when Renee filed his lawsuit back in 2008, he had looked for an attorney everywhere, but nobody would take his case. And so he had no choice. If he didn't file the suit, then he would just lose the right. So he did what he had to do, but then all of his civil rights got violated again. Anyway, so defendant Callahan filed a motion to dismiss the allegations in Plaintiff Kay Stevens' fourth amended complaint on June 10, 2011. So Callahan's just basically saying, get rid of my allegations. Like, how do you do that? Defendant Reese granted defendant Callahan's motion on July 13, 2011 in whole without legal opinion. Defendant Reese inserted his personal opinion about the validity of some of plaintiff's allegations with extreme bias and directed the plaintiff to amend her complaint. So they keep telling me, change your complaint, take out all your allegations against Scott. On July 17, 2011, Plaintiff R. Stevens filed a federal lawsuit, docket number 311CV736HU, against Nike based on his 4th, 5th, and 6th EEOC charges. Plaintiff K. Stevens filed her 5th amended complaint against defendant Evangelisti Kocher on July 29, 2011. Defendant Callahan filed his motion to strike the allegations in Plaintiff K. Stevens' 5th amended complaint on August 12, 2011. So basically they're saying I can't say that Scott did anything to me. On August 15, 2011, Plaintiff R. Stevens filed a federal lawsuit, docket number C11CV1013HU, against the state of Oregon as well as all the judges who oversaw the proceedings in his state case against Nike. Plaintiff K. Stevens and Plaintiff R. Stevens convened with Defendant Maurer, who is the chief judge down at Multnomah County Courthouse, Defendant Callahan, and Defendant Kocher for a status update conference on August 15, 2011. Same date. That happens all through this complaint. Defendant Maurer attempted settlement negotiations, which failed, and she reassigned the case to Defendant Nelson based on Plaintiff Stevens informing her that she filed a judicial fitness complaint against Defendant Reese. So she changes the judge, and the update, the conference failed because they were just completely rude to me and basically saying that, maybe they give me a couple $1,000s and I needed to just go away. After how they did us all completely foul, appointed me Kadira's guardian ad litem, which was against federal law, lied to me about what the case was about because it was a case of child abuse, taught an Amy should have been on trial. I mean, the whole thing. Just lied straight to my face. Put on a fake trial. And now, I can just walk away for $2,000, like, just get out of here because they think I'm nobody and nothing. I don't think so. Anyway, Defendant Nelson heard and granted without opinion Defendant Callahan's motion to strike the allegations in Plaintiff K. Stevens' 5th amended complaint on September 14, 2011. So all the judges keep saying, no, you can't say this stuff. And Nelson, all these judges, Reese, just, come on, you guys. Don't even do your job. It's just ridiculous. Plaintiff K. Stevens filed a judicial fitness complaint against Defendant Nelson, alleging that she was attempting to cover up the abuse of Plaintiff K. Stevens. Defendant Nelson refused to recuse herself from Plaintiff K. Stevens' lawsuit, and the Judicial Board of Fitness dismissed Plaintiff K. Stevens' complaint without explanation. Straight up. Straight up. I'm telling you. Plaintiff K. Stevens filed a motion to reconsider Defendant Nelson's ruling on September 30th, 2011, specifically requesting that Defendant Nelson explain why and how she granted Defendant Callahan's motion to strike. Defendant Nelson denied the plaintiff's motion without legal opinion on November 16, 2011, and directed her to amend her complaint. They wanted me to take all of my allegations out, all of them. Plaintiff K. Stevens filed her 6th amended complaint on October 7, 2011, which added Plaintiff Q. Stevens and her claims as a plaintiff by and through her duly appointed guardian ad litem, Krellin Stevens. The 6th amended complaint also added Defendant Kocher and Defendant Evangelisti as individual defendants. Plaintiff K. and R. Stevens requested that the Federal Bureau of Investigation investigate the circumstances surrounding Plaintiff Q. Stevens' injury and how it was handled by the legal system. On March 14, 2011, Defendant Glenn G. Norling, on behalf of the FBI, refused to investigate and told the plaintiffs to never contact the FBI again. So once again, we have a letter actually saying that. Plaintiff K. and R. Stevens reported to the Office of the Inspector General that the state of Oregon was covering up child abuse and that the local FBI was refusing to investigate, and the Office of the Inspector General refused to investigate any of the issues brought by Plaintiff K. and R. Stevens. On July 5, 2011, Plaintiff Q. Stevens was diagnosed with type 1 diabetes after being rushed to Emmanuel Hospital in full-blown ketoacidosis. So, all the while, for 4 years, Kadira's body is in internal distress. She's got blood poisoning, liver damage, kidney damage, and basically her liver was pushing out all this glucose to try to help her heal, and it just burned out her pancreas. I mean, it makes sense. Because they did nothing to stabilize her at all. I mean, they didn't give her fluids, they didn't do anything for her. They just wrapped up her leg and sent her home. So all this while she's dying, OHSU knows it. We took her to Emmanuel Hospital, because while I was litigating my case against Kocher, I started not to trust the hospitals. I knew something was up. So anyway, we're just really thankful that she went to Emmanuel, because we really believe that OHSU would have just let her die, because that's what they got paid $100 million to do. So anyway, in the summer of 2011, plaintiff K.N.R. Stevens visited Joseph Polito, MD, at the Oregon Burn Center, where he told them that plaintiff Q. Stevens should have been transferred to the Oregon Burn Center for treatment based on the diagnosis of the ER report from Providence St. Vincent Hospital and from OHSU Hospital. Plaintiff K. Stevens contacted the American Burn Association and was told that based on the recommendations of the American Burn Association, plaintiff Q. Stevens should have been transferred to the Oregon Burn Center for treatment. Plaintiff K. Stevens filed complaints against all of the doctors involved and defendants OHSU and Providence Hospital with the defendant Oregon Medical Board. The Oregon Medical Board dismissed the complaints without an explanation. Just like that. That's how they do. On April 22nd and May 2nd, 2011, in depositions held by plaintiff K. Stevens, defendant Kocher testified under penalty of perjury that he served on a committee with defendant Rex Burkholder, defendant Todd Burkholder's brother, an Oregon politician. He testified that he did work for the law firm that is defending Nike against plaintiff R. Stevens. Can we say conflict of interest? On January 13th, 2012, defendant Callahan filed a motion in the current county case 1008-1100. Well, that's over now because they just threw it out, but that's how they do. There's no trial for us. Limiting plaintiff K. Stevens from submitting evidence or commenting. So he filed a motion limiting me from submitting evidence or commenting at trial on any of the emotional distress I experienced, or she experienced. Defendant Kocher's connection to defendant Rex Burkholder, plaintiff K. Stevens' appointment as plaintiff Q. Stevens' guardian ad litem, and the fact that defendant Kocher did not report plaintiff Q. Stevens' injury to the police. The fact that defendant Kocher used plaintiff K. Stevens' medical records in plaintiff Q. Stevens' civil trial. Any of defendant Kocher's conduct at plaintiff Q. Stevens' civil trial, and the fact that this was a matter of child abuse and that there was a conspiracy to cover it up. So basically, he filed this motion with Judge Nelson, basically saying that the judge needed to limit me from talking about anything that happened, gag me. Does that make sense? On January 17th and 18th, defendant Nelson, defendant Callahan, defendant Evangelisti Kocher, defendant McQuiston, defendant Burkholder, and defendant Lockenmeyer attempted to hold trial proceedings at Multnomah County Courthouse to force plaintiff K. Stevens to amend her complaint and go to trial against defendant Evangelisti Kocher with the amended allegations, which they wanted me to take out all my allegations except for one, which was for the money I spent on the appeal, and that's it. But I couldn't say anything about anything else. What's the point in that? On January 17th, plaintiff K. Stevens informed defendant Callahan and defendant Nelson via email that she would not be participating in the proceedings because, this is what I told them straight up, that she would not be participating in the proceedings because she does not engage in covering up crimes. That's what I told the judge. I don't engage in covering up crimes. So anyway. Plaintiff Q. Stevens was denied proper medical attention from defendants OHSU Hospital and Providence Hospital, denied an investigation from every authority official, has not received compensation in any form from anyone, and has been unable to get any legal assistance. Plaintiff Q. Stevens is 13 years old. She was 13 when we filed this. She's 15 now. Defendant Nike filed documents with the EEOC and the Washington County Courthouse stating that plaintiff R. Stevens' layoff was due to the shutdown of Exeter Brands Group, but to this day, Exeter Brands Group is still in active business as so documented by the New York State Department, and they were up until this year. Very interesting. On January 22nd, 2012, plaintiff K.N.R. Stevens discovered that defendant OHSU Hospital had knowledge based on a comprehensive metabolic test taken on January 22nd, 2008, that plaintiff Q. Stevens was experiencing internal distress and severe sepsis after her burn injury occurred. So, that is all of the facts in our case. We've filed documents in the court around this. We've contacted the FBI. We've contacted a lot of people. We've even written a letter to Barack Obama, the whole thing. These people don't do their jobs. So, I don't understand. I mean, they don't do anything. They don't do anything for anybody. They just work to cover up whatever they need to cover up to make sure they can make their money because they've lost their minds. All they see is money. And it's got to go. So thanks for listening. I'm going to read the statement of claims and allegations is more like written like a story. And that's what our theories on what happened based on the evidence that we have here. So I'm going to put that up a little bit later. So look for that video, because if the facts sound kind of crazy to you or it's kind of too much to take in, I think the statement of the claims and allegations is a little bit easier. So I'll be posting that too. And thanks for watching.